been doing this. One, Mr. Elijah, who was giving the editorial comments in the first video, he was here to be questioned. In this case, this individual who's in charge of the audio-video feed is not under the state subpoena. He could be. If they chose to do that, they could have him here and he could testify to his opinions and we could cross-examine those. That would be acceptable. What Mr. Binger is saying is, my client is there, so he knows all this. There's no proof that what that individual is seeing, filming, and commenting on, my client is looking at it, seeing it, or part of it. That's why that person needs to be here to testify. I have no problem with this detective testifying as to people, places, and things from this video. We stipulated that. I did not stipulate to the editorial comments. I have no objection. Obviously, there's no basis for it when they want to play statements of my client that are on video. That's not hearsay. But this and his statements regarding militia, things like that, that is hearsay.
So we've got two complaints here, or two objections. One is the confrontation clause. This is not testimonial. It doesn't even fall anywhere near testimonial. Therefore, confrontation clause, I don't believe, is a valid objection. When it comes to hearsay, Your Honor, we had a pretrial dispute regarding things that Joseph Rosenbaum did all night long that were not witnessed by the defendant. The defense argued that those things should come into evidence because they show the context, they show his character, they show propensity for violence, they set the scene here. And I argued to Your Honor that if the defendant didn't personally witness it, it shouldn't come in. That argument failed. We allow them to come in. We've heard in the opening statement a lot of things about Joseph Rosenbaum that I know personally, and the evidence I think will demonstrate that the defendant never witnessed that night. But they're going to come in to attack the character of a deceased individual. And I understand the Jackson ruling. I've read that decision. I understand all of that. The difference is, Your Honor, this is exactly what the defendant witnessed. He is right there. Now, counsel is asserting that the defendant isn't aware of what's going on at this scene. I don't know that. The defendant knows that. Well, he has the right to testify. I'm going to. There's a.
Wait a minute. You're right. He has the right to testify. He has no obligation to testify.
Absolutely not. But if he's going to get,
and if you're going to,
he is present. He's within a few feet of all this stuff going on. So it is a perfectly reasonable understanding that he is witnessing this and that this is forming his state of mind. He is seeing confrontations. We are showing the jury those confrontations. These are occurring right in front of his face. So this is him right there. I'm not showing stuff that was 10 blocks away. I'm showing what was right in front of him as he's witnessing. We've already seen him in this video. Now, if the defense wants to argue he didn't witness it, if they've got evidence to suggest that, they can argue that and the jury can make a decision. This is a factual dispute. The hearsay objection, again, these are not being, no statement that I'm showing this view is being offered to prove the fact of the statement. But hearsay does not necessarily have to be admitted for the truth of the matter asserted to be relevant. It can be admitted for other purposes, such as present sense impression, state of mind. These are excited utterances that are going on in the heat of a conflict in a scene like that. So there are plenty of hearsay objections.
There are so many things you're touching on that I want to be able to tackle them all.
Sure.
And this present sense impression thing, what the defendant was aware of with respect to what was pictured in the video, and I'll give you that even though the camera's aimed on him and is looking into his face and what he's seeing is actually the videographer, but I'll grant you he's there, but you're accomplishing the result as to what was available for his scrutiny when you show the movie, the video. I don't see where the commentary by the videographer is part of his sources of knowledge. That's number one. Secondly, getting back to the Jackson case and the ruling the other day, and I'm going to comment about the media again because there was a gentleman on TV night before last who said this is the most divisive case in the country today. So anything that undermines public confidence in what happens here is very important. It's important for this town. It's important for this country to have people have confidence in the result of this trial, whatever it is. And I don't care what it is, but people have to be confident. There are people on the media, on reputable sites, that are saying things that are totally bizarre. And I'm going to cite one only because it